Thank you all for joining us. I know we'll have more people joining throughout, but appreciate everybody tuning in and appreciate our guests tonight being here for a webinar about Schedule PC and some other related issues that I know are top of mind for a lot of current and former feds. My name is Jenny Mattingly. I'm the Vice President for Public Policy and Stakeholder Engagement at the Partnership for Public Service, and really excited to be doing this webinar tonight with our friends from Rise Up Legal Network, Civil Service Strong, and AFGE. And so I know you've seen us before, this is one in a series of sort of virtual town halls we're doing to bring you, answer questions, bring you information, share resources. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy. And we've got a lot of resources, including our FedSupport hub, which we'll put in the chat along with other links from our partners here, and we'll do introductions in just a moment. Before we do so, reminders, there is a Q&A function throughout the webinar. Please feel free to drop questions in that Q&A function. We'll do our best to answer them. And thank you to those of you who also submitted questions in advance. We'll get to those too. But given the complexity of the topics, we may not be able to address every question. We'll try to do our best, and we will be doing more of these in the future. So if we didn't get to something and you still have that question, please let us know. There'll be a poll at the end to add those points to it. And again, this is recorded. You can see it on our FedSupport hub, our YouTube channel. We'll put those links in the chat as well. So why don't we go ahead and get started with introductions. And let's go with our Civil Service Strong friends first. Rob, Mike, want to do a quick intro?
Happy to
Mike,
start.
why don't you go ahead?
Yeah, I'm Mike Martinez. I'm the managing counsel at Civil Service Strong at Democracy Forward. I was previously at OPM as the deputy general counsel. I got to work closely with Rob and some other folks here on the Civil Service Strong team.
Rob, over to you for a quick intro, and then we'll get to the others.
Thanks. My Zoom just flashed off and came back on real quick. Sorry about that. Rob Shriver, Managing Director of Civil Service Strong with Democracy Forward and former Acting Director of the Office of Personnel Management.
Great. Thank you both. Rashab, why don't we go to you?
Thank you, Jenny, and thank you all for attending. I am Rashab Sanghvi. I am the General Counsel of the American Federation of Government Employees, otherwise known as AFGE, and we represent over 800,000 federal employees. And again, thank you for being here.
Great. Thank you. And Jeff, over to you.
Good evening. I'm Jeff Nesvet, the Acting Executive Director of Rise Up Federal Workers Legal Defense Network. We provide support and resources for federal workers, something I was as a civil servant for over 4 decades.
Yeah, great. Thank you. Appreciate you all being here to share your expertise and insights. And as I mentioned up at the top when we were just getting started, we're here to discuss Schedule PC, Schedule Policy Career, which for some people, it may be easier to call it Schedule F. That was what during the first Trump administration, what the executive order was called. It's now Schedule Policy Career, and it is a little bit different than Schedule F. So we'll dig into that tonight about differences, who it covers, answer some questions. But I thought really it would be a good idea to start even farther back, going into some of the history of the merit-based civil service, the spoils system, kind of where the system we're in comes from, because to understand Schedule PC and its implications, it's helpful to understand the history. And for those of you who haven't watched Death by Lightning, I'm going to turn to Rob to give us a quick history walkthrough so we can understand kind of the context of what we are looking at today.
Thanks, Jenny. It's great to be here with everybody. I think we have some slides that we can pull up. Yeah, that's great. So our civil service is a nonpartisan, merit-based civil service. That means that people, for the most part, are employed based on their skills and abilities, their the merit that they have to do the actual jobs that are required. It wasn't always this way. Back in the 1800s, we had something called a spoils system, and what that meant was that whoever was elected president basically hired people who were that person's supporters or champions or had connections to that person. And they were not hired based on merit. Jenny mentioned Death by Lightning, the Netflix series that provides a good sort of picture of the context then and the corruption that was occurring under that spoils system. And so out of that, which ultimately led to the assassination of President James A. Garfield by the quote disappointed office seeker, somebody who thought that they deserved a job in the Garfield administration because they supported him during the campaign. His successor, President Chester Arthur, worked with Congress to enact the Pendleton Act, and that was signed into law in 1883. And that is the law that created the merit-based nonpartisan civil service. And that has been the foundation of our democracy and led to our civil service really being sort of the gold star when other countries look to what are the central tenets of our democracy in the United States that have made it enduring. They point to our nonpartisan merit-based civil service as critical to that. Over the 140 plus years since the Pendleton Act was enacted, there have been bipartisan efforts to strengthen civil service protections for federal workers. That doesn't mean that you can't discipline or downgrade or fire federal workers. It just means that you can't do that for partisan political reasons, or you can't retaliate against people who are whistleblowers or do anything else that's not based on merit. That's what the core really is. So Congress has strengthened those rules over time. One of the biggest reforms that came about after the Pendleton Act was the Civil Service Reform Act of 1978. That was created a significant change in the structure of the civil service. Prior to that, the Civil Service Commission was both a policy maker and the adjudicator of civil service matters. That had persisted for, again, the entirety of that period of time from the Pendleton Act to the Civil Service Reform Act. Congress took a look at that structure and decided that a better structure that would be more in line with a nonpartisan civil service would be to break out the management functions of the Civil Service Commission and assign those to the Office of Personnel Management, and then have separate independent adjudicatory bodies, the Merit System Protection Board and the Federal Labor Relations Authority, to handle claims arising from the federal employment context. Later on, the Office of Special Counsel was split off from the Merit System Protection Board to handle specifically whistleblower matters, protected disclosures, and other prohibited personnel practices. And that came about in the post-Watergate era, those civil service reforms. Again, from 1978 up until 2020, you saw bipartisan efforts to strengthen the nonpartisan merit-based civil service. That has been the theme throughout since 1883, is strengthening nonpartisan civil service. In the last year of the Trump administration, the first term for President Trump, they issued something that was called Schedule F. And Schedule F is a technical HR tool that was used for to wreak major changes in the merit-based civil service. The schedules are like different types of appointments into federal jobs, and they have different rules governing what appeal rights and other things might apply to you. And for the most part, all of the schedules, other than the one that has applied traditionally to political appointees, have required merit-based hiring and have had some level of civil service protections for federal workers in those schedules who are subject to performance or based or misconduct actions. Schedule F essentially took away those rules for broad swaths of the federal government. It created more of an at-will type employment situation for people who are connected to policy work. And Mike can go in a little more detail into that. But that was a major change that was done simply through an executive order and then agencies identifying positions that fit this new policy related category. And estimates were anywhere from 50,000 to potentially a few 100,000 people would be moved into the Schedule F through this technical HR process that would have the effect of stripping them of civil service rights that came to be starting in 1883 and had been strengthened all the way through. So that's the history. Well, to bring you up more to the current time, I'll turn it over to Mike, our managing director.
And Mike, before
sure.
you get going, no, Rob, thank you. I just will throw something out as you may be getting ready to talk through this. But Rob mentioned something, and I know we've had some questions ahead of time about this, of where the schedules come from, that Schedule F and others aren't actually statutory schedules. So hoping you can talk a little bit about that in your role. It just, my understanding, and Rashad, maybe you'll go into this later too, is that really Title V, which is the part of the US Code, gives the president the ability to create new schedules through OPM, but doesn't specify what they are. So, and I think too, as you're talking about the 2024 rule and Schedule F, one of the other things I think folks will want to hear from you on is who it applies to. And I know that's a trickier question than it seems in terms of what Schedule F is and does and what the 2024 rule did. So over to you, Mike.
Yeah, happy to jump in here. It is very complicated, and there are a lot of resources that we'll be putting out today to better describe this. And I'll talk in general terms about how this structure came to be and kind of what we're seeing now. And then later on today, we'll get into some more questions. But you should remember, as a default, the baseline is career positions are in the competitive service. That's the default. But then there are exceptions to that. And the exceptions really have sprung over time for different reasons. Either it was impossible to examine for a position, or that there was something that made it very difficult, or just some other thing that necessitated that exception. So that's where you get the schedules. When I, back in the day, was a DOJ trial attorney, I was a Schedule A employee, because that's where all the attorneys in government sit, in Schedule A. And the reason they were in Schedule A was because they were accepted because of an old writer that said you're not allowed to examine attorneys. There's Schedule B, as we've heard. Schedule C are political appointees. There's Schedule D and E that were created more recently. And then we have Schedule F. Now that's Schedule Policy Career. And then we have Schedule G, which is the newest schedule, which relates to purely political appointments too, quite similar to Schedule C. So you have A, B, C, D, E, Policy Career, and then G, just to make things more confusing. And we'll get into those a bit more in detail in a bit. But you should also remember, as a baseline, that all career civil servants have protections from termination if they hit certain threshold probationary periods. If you're in the competitive service, after 1 year, you get those rights. And if you're the accepted service, generally you get those after 2 years in that service, assuming you're not in Schedule C, which is the political appointee schedule. What Schedule F tried to do is to take advantage of an exception that has been in statute for a long time. It's been, even before the CSRA in 1978, this exception has been around decades before that, and really has always meant political appointments. And that exception is for positions of a confidential, policy determining, policy making, or policy advocating character. So what do those terms mean? It is kind of the central piece of this Schedule F, Schedule Policy Career. In 2024, when I joined OPM, at that point, President Biden had already rescinded Schedule F. There was no Schedule F, but we really wanted to make it very clear what these terms meant. And they were a term of art that have always meant political appointments. So we issued a rulemaking in 2024. Prior to that, we had the proposal that garnered over 4,000 comments. The vast majority were in favor of our rulemaking. And if you exclude boilerplate comments, upwards of 90% were in favor of the rulemaking. So not only did it define this exception to mean political appointments, it also had a process for how to move employees from their positions to something new, some new schedule, to have more guardrails around this process. And those are kind of the two things you should think about when you think about the 2024 rule, the definition and the processes that were put in. So now what we have most recently with the scheduled policy career rulemaking is that the 2024 rule is gone. So the definition defining that exception to be political appointees is gone, and the processes that we put in place during my time at OPM are now also gone. So that's what the 2024 rule did. And before we continue on, Jenny, do you want me to steer in any direction?
I think that's super helpful, because I do think that a lot of this, and what I'm hearing you say too, which I think is helpful to remind people, is that so much of this, whether it was the original executive order, the 2024 rule that OPM promulgated, and then now Schedule PC, executive order, and a new rule that's come out recently that helps implement that executive order, none of those are statutory. They are all actually executive actions. And so that's why we're seeing things change, come and go. And so it does create a bit of whiplash for folks. Some things are the same, some things have changed throughout the course of those. So,
right.
Yeah, but I think that's helpful. And could you, Mike, a little bit just share with folks, even though OPM had a rule in 2024, there's also a process to undo those, and the executive order this time around is what did that.
Yeah, that's right. So agencies have the authority generally, or at least OPM did, to issue rulemakings like the 2024 rule to do things like defining the exception of confidential policy determining, policy making, policy advocating positions to make things more clear and in line with congressional intent and the long-time meaning of the statutory language. And you're right that this is not defined in the statute itself, which is why defining it was so important. There's plenty of congressional material from before the CSRA that really spoke to this, so that Congress always understood it to mean political appointments. And all of a sudden, the Trump administration in 2020 thought it found some sort of magic release valve and tried to use that exception in a way that no other president ever thought to use it. So the rulemaking power that OPM had, we used it to clarify that language. Because you're right, it's not defined in the actual statute itself. And maybe taking one more step back, another piece of Schedule F is the president's ability to create accepted service categories. So these schedules, that is fairly non-controversial. The president can create these schedules. And I think the important part for Schedule F is, and Schedule Policy Career is what's the purpose of this category? And this is the first time a category has been created just explicitly to strip career employees of their rights.
That's helpful. And I think that's a good pivot into sort of Schedule F, where we were and where we are now. And I know you've thought a lot about this. Rushab, I know you've also been thinking a lot about the definitions of what the rule does, who it covers. And we've talked a little bit about the definition, but I think if you, Rushab, could jump into a little more of how is this similar or different to Schedule C, to what people are used to? Who are we talking about when we talk about policy making, policy confidential, the entire litany of words that go with the definition?
Sure. Yeah. So in terms of who Schedule PC covers, right, and how it's different than Schedule C, I mean, I think one thing to keep in mind is, Schedule C historically has mean, and it is for political appointees, right? Schedule PC, the administration claims is still for career employees who've competed for their positions. Yet it essentially, takes away the rights that competitive career employees have had and puts them in a very similar position as Schedule C employees. Who the administration is going to determine is covered by Schedule PC. We don't know precisely yet, right? There is the definition that Mike talked about. OPM did put guidance out, but until we know who agencies have designated and who the president will, move to that schedule, we don't actually know who it will cover. There are we do believe that, it will likely be employees at a higher pay grade at the GS 14, 15 level. It will, attorneys may be more likely to be covered, for example, positions that are more likely to fit that definition of policy determining, policy making, or policy advocating. But again, we know with this administration, they are going to try and stretch this as far as possible, or they may try and stretch it as far as possible. OPM originally said about 50,000 federal employees would be covered, and OPM reiterated recently that it believes that estimate was accurate. So that's where we are. In terms of what the rule does, just to the basics of it is it removes the protections that competitive civil service employees have had for generations, right? It takes away, it strips employees of Chapter 43 rights. So essentially, the rights you had to have performance improvement plans, an opportunity to improve, and the rights to appeal those actions taken under Chapter 43. So performance actions. It also removes Chapter 75 rights. Those are the rights you have when you are disciplined, you're terminated or you're given a suspension over 14 days. In general, again, it takes away pretty much most of these rights that competitive service employees have, including most rights to appeal to the MSPB. And it also takes away, which is very concerning, and I know we'll get into this later, it takes away or transfers whistleblower protections.
That's right. I think that's important. And as you said, we'll get into that. A couple other things that I'm hoping, Rashab, Mike, that you can flag that might be of interest to people. Who designates who in their agencies is in Schedule F? Because I think people are wondering, am I just given a notice right away? Is it the agency head? Is it OPM? Is it, the White House? Mike, who decides where those lists of, or did I say Schedule S? Schedule PC, we've now gotten into alphabet soup, but Schedule PC, who's in charge of designating what those lists look like?
Yeah, so after the inauguration, there was an executive order by the president formally creating Schedule Policy Career kind of as a shell. In order to fill that shell, the president in the executive order said that the agencies had to look at their positions and then recommend to OPM the positions that would be put into Schedule Policy Career. So over the past few months, agencies have been doing that. They've been creating lists and they've been sending them to OPM. And in the rulemaking itself, it talks about the process from here on. So OPM will look at those positions and then we'll do some sort of analysis and then we'll recommend to the president which positions should be put into Schedule Policy Career. And at that point, as per the rule, the president will issue an executive order formally placing certain positions into Schedule Policy Career. And that's when these effects will hit those positions. The rights will go away, and there are various other effects we could talk about today, but that is a sequence of things. And the rule was finalized on February 6th, and it has an effective date of 30 days, so it's not yet effective, although it is there. So on about March 6th or so, depending on what day of the week that lands on, then that's when you should expect Schedule Policy Career to be in effect. And that's when we may start seeing more activity from there. But we don't have an exact timeline of how or when OPM will send these names or positions and how or when the president will actually act from there.
And I think that's another point that we've been thinking a lot about is that this isn't not saying this to strike alarm for folks, but this isn't a one and done sort of thing. It's not you issue one executive order, switch positions, and this can be done on a rolling basis, my understanding. And Rashab, I don't know if you all have looked at that, but it's really, there's nothing that constrains it to a certain time or a certain amount or anything else.
Yes, that's correct, right? And again, it's sort of, in some ways, there's a lot of unknowns. As Mike said, we won't really know much until, or we likely won't know much until March 8th when the rule takes effect. And after that, we'll have to wait and see what's in these executive orders. And then subsequent to that, there can be additional, executive orders that, transfer people to Schedule PC. So again, there is a lot we don't know. We are taking actions. I know not just, AFGE, but I know Democracy Forward and others, through FOIA requests and other things to try and gather information about what is going on. And again, we will know a lot more after that March 8th timeframe.
And one other question, because I haven't seen it there, but I know I've heard it in other places, and you sort of alluded to it earlier about who might fall into that definition. Can you let folks know, one, if they're senior executives, because I don't believe this applies to senior executive service, but want to check and make sure I'm correct on that. And two, if they're bargaining unit versus non-bargaining unit. And I know folks are asking about whether that has any bearing on things.
I'll let Mike answer the SES question, the senior executive question, because I'm not too familiar with that piece. But with respect to the bargaining units, OPM actually put out guidance, and this is, what we believe should be the case, is that if you are transferred to Schedule PC, you do not automatically lose your bargaining unit status. So if you are in a certified bargaining unit, you will remain in that bargaining unit if you transfer to Schedule PC. However, the sort of the quirk to that is that OPM has basically recommended that if an employee is transferred to Schedule PC or a position is transferred to Schedule PC, the agency should petition the FLRA to remove that employee from the bargaining unit, because generally policy, confidential and policy-making positions do not qualify for inclusion in a bargaining unit under the labor relations statute. So, just from as a quick timeline perspective, what would happen is if your position is transferred to Schedule PC, you would remain protected by your collective bargaining agreement if you have one that is in effect. However, the agency would then likely very quickly petition the FLRA to take you out of that bargaining unit, and there would be proceedings over that.
So a lot of unknowns and a lot of questions in this, but things we can start seeing. And Mike, what about the senior executive service or folks in other positions?
It's a great question, and it's something we addressed in 2024 thoroughly. So I mentioned the competitive service and the accepted service. Really, the other more service that is, generally speaking, the civil services are senior executives, the SES. Those are not part of scheduled policy career. They are a separate service. They have their own adverse action rights that are in statute, which is one of the oddities of scheduled policy career, that the SES, this higher level tranche of managers in government that explicitly work on policy per the statutes, have their own adverse action protections, their own civil service protections for termination. But a lower tranche of employees would lose them if they worked on policy. That is something that has never made sense to me, and something that was addressed early in the 2024 rule. And this final rule tries to address that. But there's active litigation on whether this actually all makes sense.
Yeah, I think that, for folks listening, this is one of the harder things, is that there's a lot of unknowns with this rule still, and with how it's going to play out both in practice and in the courts. And I do think a couple of questions that I have that I'm seeing in the chat here, that just to make sure we're clarifying, one of the things I said, and make sure you all check me if there's an amendment to this, is that once the initial group of folks, 50,000, is moved to Schedule PC, that doesn't have to be the only number. The only stipulations is that to reclassify positions into Schedule PC, the president has to release an executive order saying which positions are now Schedule PC.
That's right. Yeah, 50,000 is just the initial estimate from OPM based on the recommendations they've received over the past few weeks and months from agencies. But there is no limit, potentially. It really depends on how this administration interprets all of these exceptions.
Yeah, and I think another question, just to clarify while we're talking about definitions, is for folks, is that just because your PD, your position description, doesn't necessarily have the word policy in it, or it does because it's outdated. I know that's another issue. Somebody's asking if there are positions that wouldn't traditionally be associated with policy making, maybe it's public engagement or comms or IT or others, because there is no definition, this is so wide open, those positions could theoretically be included in Schedule PC. Is that correct?
Yeah, that's right. And just to give you an example, attorneys at, say, DOJ I don't think they consider themselves to be policy making or policy advocating or policy influencing. They're a different type of employee. Yet this administration, I think, sees those as touching on policy in a way that would potentially suck them into Schedule policy career. There is some part of the final rule that addresses attorneys in government, and I think that's their conclusion is that because they're in this policy making chain, that they should be in this category.
Yeah, and some of this is just a wait and see. The definition for folks on the phone is broad enough. There is no definition. I mean, it is just the words. There is not a specific set of criteria. So I know folks on the phone, and Rob, maybe we want to bring you back in too with all of this, is to talk about, people are asking about what's next. How will this impact federal employees, beyond the moving and the losing of certain protections? How will this impact performance, or what happens to their rights for whistleblowing? Rashab, you mentioned that. I think it's worth digging into the specifics a little more of what people can expect to see. Yeah, Rashab, if you want to talk a little bit about the whistleblowing piece, because I do think that's important.
Yeah, sure. And I mean, so I think, currently, employees have protections under its 2302 of Title V when they want to against protected personnel practices. The rule essentially takes those protections, which can be appealed to the MSPB, and shifts them to the agencies. One of the guidance documents that OPM put out shortly after the rule was finalized was a template for agency PPP, or prohibited personnel practice rules. And so what this does is it takes away the independent oversight of these personnel complaints and these whistleblowing complaints. And we have said, and I think the partnership and Democracy Forward have also said in our comments, is that doing this is going to potentially create a chilling effect, right? It makes it a much harder for people to complain about or to blow the whistle if you know that your complaint is going to be heard by the agency itself as opposed to independently. So I think that's a big loss and a big issue that we hope we'll be able to address.
Yeah, I think that's something I know we've pointed out, is that so many of the things that happen that have traditionally been, in the history Rob gave before, apart from policymaking or having a sort of separate body to oversee them, is certainly a challenge in this, because it goes to agencies, it goes to places that traditionally don't adjudicate these sorts of things like whistleblowing. So Rob, I know we've been quiet for a little bit, and there's some other questions. So please, if you see folks with questions there that we haven't gotten to, jump in. But Mike, other things that stick out to you in the Schedule PC rulemaking, because there's the executive order, and then there's a 255-page final rule. Not all of it is the rule. A lot of it is addressing comments that were throughout. But are there things that we haven't talked about with the rule that impact employees that are important to raise up?
Yeah, well, I guess one thing in particular are certain benefits that likely go away, and this is because we should remember that this confidential policy determining, policy making, policy advocating was always considered to be political appointments. So those just carried fewer benefits that's the way Congress intended. Some of those that could be impacted are student loan repayments, and we call the 3 R's: recruitment, relocation, and retention incentives. And by statute, those cannot go to confidential policy determining, policy making, policy advocating positions, because that, like I said, was supposed to be for political appointees. So that they were carved out from these incentives. So now there's a real question of what happens to folks who are receiving these benefits. And the rules tries to address that by saying that if you're in a current agreement, that will likely continue. There's the real question: what happens when those agreements end? And I think there should be no expectation that you will be eligible once you're moved into this position for those incentives once your current agreement expires.
Yeah, and so that's something to remain to be seen. Rob, jumping over to you.
Yeah, I was just going to jump in, Jenny, and add that, okay, so people that are moved into scheduled policy career are not like set to be terminated automatically or anything like that. Although I can certainly imagine if I were somebody in the position, I might be concerned about the way that I carry out my job now, knowing that these protections that once ensured that I would be, evaluated and judged based on merit have fallen by the wayside. That was something we were concerned about when we did the regulation in 2024. In fact, we tried to, through the reg, create an appeal right for folks to go to the MSPB at the time that they were designated as what was then Schedule F, because of exactly that concern that if you no longer have civil service protections, it might affect the way that you go about your job in a negative way. And so like that appeal right has been taken away. And I think it remains to be seen and likely will be litigated what kind of rights people do have if they're put on to schedule policy career, and then if an adverse action is taken against them. And I think the other thing that I wanted to say is, there's some questions in the chat about, and we've addressed this a little bit. Well, regulations can't override statutes, and like, how can they do this if they don't have the authority? And I think that's an important point to make about the 2024 rule. So even though that rule has been revoked, that rule goes to a great length to interpret the laws that are on the books and explain why civil service protections are inherent in the Civil Service Reform Act, and that there are legal problems with just stripping them away through a tool like Schedule F, or now Scheduled Policy Career. And so those issues will ultimately be litigated. Another person said, yeah, but litigation takes a long time, so what can Congress do? You're right. Like, litigation does take a long time, absent extraordinary, like, preliminary relief. And so, like, it's important that that fight in the courts continue to happen. Congress has considered bills in the past that would put into the law some of the types of clarifications that Mike talked about that were in the 2024 OPM regulation about what does policy advocating really mean, and things like that. So there have been efforts in the past, and Congress can still do that. They can still clarify that this scheduled policy career is not consistent with the statute, if that's what they wanted to do. And the last thing that I would say is that Mike mentioned that the rule in 2024 from OPM had 4,000 comments that were, the vast majority were positive of sort of the preserving civil service protections. And this regulation, by this OPM, had 40,000 comments, 10 times as many, with like 94% were against it. So these are all things that will have to be grappled with through litigation that Democracy Forward, AFGE, and other organizations are pursuing. Oh, you're on mute, Jenny.
I am on mute. It went back. Rushab, you look like you were going to jump in on
Yeah,
that.
I just wanted to reinforce something that Rob was saying, which is that, well, this is, there's no question this is a terrible rule. We believe that, it's unlawful. There's going to be a lot of litigation. For those of you who are on the call, again, this is not, it doesn't mean just because we're talking about these rights that are gone, it doesn't mean that you're going to be, you're going to be terminated on March 9th, right? That's not going to happen. And it's so important that you continue to take advantage of resources like this, advantages of resources that Democracy Forward, that your union and AFGE put forward, because it's so important that you stay in those positions to sort of to make sure that what we believe this administration is trying to do, which is politicize the civil service, to make sure that doesn't happen, right? Because it's important for all of us, that we still have people in these positions fighting for Americans and making sure that they're doing the work in a nonpartisan way. So I just wanted to make sure to reinforce that where there's a lot of scary things happening, and we're talking about how your rights are being stripped. But understand that we're going to provide you, all of us on this call, provide you with information on the rights that still exist and what we're doing to make sure that you can continue to do what you do, which is to serve the American people, right? And again, we are so grateful, and we should all be so grateful for you, for taking an interest in this, and continuing to do your jobs.
That's such an important message, because you're right, there is a lot of important work that everyone's doing, and that's still there, and folks are still needed to be doing that. And Mike, I saw you jump off of mute there.
Yeah, I just wanted to, there's one point I've been wanting to kind of sprinkle in here, because I think it's kind of tells us kind of how we ended up here. And the rights, starting from the Pendleton Act through the Lord Lafayette Act in 1912, through the Veterans Preference Act in the 40s, through the CSRA, it all went in one direction. It was more rights to employees. And I think throughout this rulemaking, this latest rulemaking, there seems to be the perception that these rights were a giveaway to the civil service. And that was never Congress's intent. I mean, Congress has a vested interest in a non-professional expert civil service that's going to carry out its programs, that's going to make good use of the money when it's allocated, that will ultimately benefit the American people. And that's really the reason why these protections have built over time. So, I just want to kind of push back a little bit on the rulemaking's kind of central thesis that this is all a giveaway to the civil service, and it should be scaled back in some way.
Yeah, and I think that's been one of the biggest issues that we've been talking about throughout, is this politicization versus a professional, nonpartisan, expert civil service, people who actually are carrying out the work in the agencies. One of the things around that politicization that we haven't talked about, particularly that's in the rule, are the prohibited personnel practices, or the PPPs. And the rule itself does say that agencies, and this goes to the sort of the OSC piece, the Office of Special Counsel, the rule says that people cannot be fired for political reasons. I'm paraphrasing the rule, but that is sprinkled throughout this new rule. My concern, and I'm curious your take on this, is that there is no way, without ability to appeal or without ability to go to Office of Special Counsel, how would you show it if your movement to Schedule PC or any action that was taken after that was for political reasons or not? And so I think if you could speak a little bit to what you've seen in there about prohibited personnel practices, the PPPs, and just what people should be on the lookout for.
I'm happy to start. So, as Rashad mentioned, and with regards to whistleblowing, this is all part of the same statute, 5 U.S.C. 2302, which includes PPPs. And just to give you a sense of what that could be, if you are an employee and you feel like you're being discriminated against based on your partisan politics, for example, that is a prohibited personnel practice. Traditionally, what would happen is you would bring a complaint to the Office of Special Counsel, which is an independent agency that is separate from the MSPB, and they have a prosecutorial function where they go and investigate your complaint and make sure that if there is validity to that, they can rectify it by going to the agency, and there's a series of different things they could do. What this scheduled policy career rule does is those folks in that confidential policy determining, policy making, advocating positions are now excluded by statute from 2302 wholesale. So if you feel like you have a PPP that you want to bring a complaint about, you can no longer go to the Office of Special Counsel. What OPM has done through guidance is to tell agencies, you handle it internally. Your Office's General Counsel now will take these complaints. So in the guidance, there's actually two guidance documents. There's an initial one and an additional one that came a few days later. I believe in the initial guidance, it instructs agencies how to actually handle these complaints. So it's not just partisan discrimination. It could be a variety of other reasons that normally would go to the Office of Special Counsel, but now will go to your internal agency's Office of General Counsel.
And that's going to be a difference. And again, I think folks will have a lot of, once we see people, and I should say not people, positions getting moved into Schedule PC, because your position may or may not be moved into Schedule PC because it's not based on individuals, it's based on positions. And so folks may have different legal questions. And so I want to pause a minute and we'll go back and answer some more questions. But Jeff, you're on the line with Rise Up. I know folks are going to have very specific, personal to them questions. I'm seeing some about benefits, about, I'm sure there'll be questions about different things that they can and can't do. If people have legal questions, even if the MSPB appeals process has changed or OSC, Jeff, can you tell us a little bit about Rise Up and where people can come in and get some help asking and answering these legal questions?
Jenny, I'd be happy to. First, let me say, as I've said before, that all of us at Rise Up hope the day will come when the services that we provide are no longer needed by federal workers. But until that day does come, Rise Up will be here for federal workers, current and former. What does that mean? We provide a range of services for federal workers. One of the most significant is we offer free up to 1 hour legal consultations with our volunteer lawyers to educate federal workers so they understand their legal situation and their options moving forward. This is generally provided through our Zoom virtual legal clinics. To obtain a consultation, you simply have to go to our website, workerslegaldefense.org, and click on where it says federal workers at the top of the page. Then fill out the short form. We hold several legal clinics each month where we conduct free consultations. To qualify for a consultation, you will have a brief interview with one of our volunteers, either beforehand or at the clinic. Determine if you have a federal employment issue and are not currently represented by an attorney. When you have responded to an invitation for a clinic, you will receive a link to the Zoom meeting. We will be placed in a breakout room with one of our volunteer attorneys where we provide free consultations. At our clinics, we also have expert federal labor law attorneys present. If your volunteer needs assistance in advising you, they can leave the breakout room, consult with one of our experts, and return to the breakout room to give you the answers they've received. Even if you've already received a consultation from Rise Up, if you have a new issue arise, you can return to our website and sign up for another free consultation. We also offer a variety of other ways that we support federal workers. We maintain a litigation tracker that provides information about the numerous lawsuits related to federal workers that have been brought. You can review that by clicking on litigation tracker at the top of our homepage. We also have numerous guidance documents available on our website on subjects such as MSPB procedures, RIFs, and a variety of other topics. Simply click on resources at the top of the homepage. Suzanne, our general counsel, issues a weekly update on legal developments called the Solidarity Docket. Simply click on news at the top of our homepage to read it. We also participate in a variety of events such as this one to provide relevant and timely information. We at Rise Up know that this administration's unprecedented attack on the federal workforce is doing immense harm to individual federal workers and the ability of our government to function. We will be here to support federal workers as long as the need continues. On behalf of Rise Up, thanks to all federal workers for your valuable and underappreciated services. We will be here to support you as long as the need is there.
Yeah, thank you, Jeff. And I know AFGE, Civil Service Strong, Partnership for Public Service, we all work with Rise Up and support that. So it's nice to have this as a place that federal employees, former and current, can go and ask legal questions, get pro bono help, navigate some of these tricky things, because it is going to be an ongoing question, I think, for a lot of folks. And so going back, Jeff, we'll put things in the chat, links that people can click on. So appreciate that. And we'll circle back around after. But Rob, I want to give you a chance if you're seeing any questions on Schedule PC that we haven't answered, because after that, I do want to pivot to a few other things that I've seen, like Schedule G and some other rules that are out there. But let's make sure if there's anything we haven't hit on.
Yeah, I think there's a category of questions, Jenny, that are about like, how do I know if I'm on Schedule PC? They say 50,000 jobs, but when you read the description, it sounds like a whole lot more than that. If they put me on Schedule PC, can I be put back? Like, what do all those mechanics look like? So I can just maybe hit through a few of these quick. So we think what's going to happen is when the reg takes effect, I think Mike has talked about this, the president will take some action. And then we would imagine that employees who are reclassified as scheduled policy career, there would be some way that you're notified of that. When that happens, if you have legal concerns, like that's a great time to connect with Rise Up. If you have any questions about what that paperwork looks like, or of course your union if you're in a union. The administration continues to hold to that 50,000 number. I agree with the commenter that when you read the way they're applying the standard, it could be a lot more than that. And also, as you've mentioned, Jenny, there could be an initial tranche of positions, and then there could be more positions later that are transferred to Schedule PC. There also could be positions that are hired through other authorities and put on Schedule PC once they come on board. So, there's a lot that we don't know yet, and that we're going to have to wait and see. But again, like if you're an employee who gets information from your agency about being moved, that's a good time to connect with your union rep or with Rise Up. And then as to the question about could you eventually like be moved out of Schedule PC? I mean, these are supposed to be determined based on the position and the duties of the position. And so if your position is moved in and the position doesn't change, the duties don't change, then it shouldn't move back. But if the duties of the position change, or if there is some reconsideration of the way that the regulatory standards apply to certain positions, then they could potentially transfer you back. I don't think there's any obstacle to doing that. It's just a matter of whether the standards are met for that. So those are some of the ones I saw some lingering. Oh, and there, I think just to clarify again that we said that Schedule PC does not apply to SES positions. It's the general schedule position.
But SLST positions are different, especially SL positions. I know somebody mentioned equivalents because those are in the competitive service. They are not in the senior executive service. So senior level positions are a little bit different for folks who happen to be in those. And one other thing I will just flag for people too is that, Schedule PC, you can also be hired into those positions, just like any other schedule. So you may also see if and when there's hiring that there are positions listed as Schedule PC positions too. And so just something to keep an eye on as well. And we haven't seen that. Rushab, go ahead.
Oh, I just wanted to add, because I saw a question in the chat about RIFs. And so the OPM guidance has indicated that, the RIF procedures would still apply to employees in Schedule PC. I know, there is a proposed rule that is changing, appeal rights for RIFs, but the fact that you were put on Schedule PC doesn't eliminate, the requirement, the RIF requirements that are currently exists. And on a related note, and I think I saw this earlier, was you also still have rights under the various EEOC statutes or the discrimination statutes, Title VII rights and so forth. The EEO process for federal employees is not altered by your placement on Schedule PC. So I just wanted to note those.
Yeah, that's a helpful clarification, because that is still an avenue that employees should know that they are still protected under those areas. So Rushab, you mentioned RIF appeals, and I know in the questions we've had somebody mention Schedule G. So this is probably a good time to pivot to a couple of the other OPM rules that are out there, partially while they're different than Schedule PC. We've been watching them because they do carry a common thread of moving a lot of actions that were formerly MSPB or OSC jurisdictions into agencies or into OPM. They change appeal rights. And so there are a couple that we've been tracking, one on probationary period appeals, one on RIF appeals, Schedule G, which is another new schedule that's come out, and suitability appeals as well. And so wondering if we can take each of those one by one. Why don't we start with Schedule G, just because it's a new schedule, just like Schedule PC. And I don't know, Mike, Rob, Rushab, does one of you want to jump in and explain Schedule G? And just very briefly what it is and how it's similar or different from PC.
Yeah, happy to do that. So Schedule G is the newest schedule. It is designed to be political appointees in slightly different policy roles as Schedule C. That's the justification. I think we have a couple of terms, policy determining, making, advocating. Schedule C, as interpreted by this administration, is limited to certain subsets of those. Schedule G would be the complement. It would be the complement to Schedule C. Unclear exactly why this administration believes it needs Schedule G in addition to C. It might be that some agency statutes limit the total number of Schedule C appointments, and this is a way to get around that by calling it something else. But it is a newer schedule designed for political appointments that wouldn't have, these processes for hiring or firing. And in the executive order that created Schedule G, it did direct OPM to issue regulations on Schedule G. So we haven't seen those yet. So while Schedule G exists as a category, it hasn't been populated with appointees just yet.
That's right. And we'll send out more resources. I'm sure we will have those in another town hall when some of these things, Schedule G and some of the others, come in. Rushab, you mentioned the RIF appeal rule. Do you want to talk about that one briefly?
Yes, sure. And so, there have been, as Jenny mentioned, a series of proposed rules that have come out. One of them involves RIF appeals. So many of you, have experienced or have friends who have experienced RIFs, and currently, when a RIF is undertaken, a reduction in force, you can appeal that. In most situations, you can appeal your RIF to the Merit Systems Protection Board and appeal, whether or not that RIF, the procedures were followed, whether or not you were put in the right place on a retention register, things of that nature. However, the proposed rule that I believe it was a few weeks ago, it actually was published in the Federal Register. It would take away that ability to appeal that to the MSPB and shift that to OPM. And that's a pattern we're seeing of these proposed rules, which are shifting power towards OPM. And OPM is not independent, right? The MSPB is there are questions about the independence of the MSPB, but the MSPB itself is supposed to be an independent authority, and you can appeal decisions from the MSPB to federal courts, to the federal circuit. By transferring these appeals to OPM, it essentially takes away the independent review and then the judicial review of those appeals. But just to be clear, that this is a proposed rule. It has not been final yet. The comment period has not ended either. I know AFGE is working with many partners, and we will be submitting comments to that rule. We work closely with Democracy Forward as well, and they've been helping us along the way with all of these different rulemakings or comments rather.
Thanks for that. There's two other rules that are similar to the RIF rules. One is suitability appeals and the other is probationary period appeals. And Rob, Mike, Rushab, anyone want to jump in and talk about those two briefly?
I mean, it's more of the same theme, and Mike, feel free to add more, but the theme is stripping the MSPB of jurisdiction and vesting it in agencies to, take away independent appeal rights, I think. But Mike, you're in the details of those. You want to say anything more about that?
Yeah, happy to. So, let me start with probationary appeals. As you all likely know, probationary employees don't really have the full suite of protections from termination, but there are some, or there were until this administration. One avenue to bring an appeal to the MSPB was if you allege that your termination was due to partisan, political, or marital discrimination, or if it was based on something that you did before your appointment to government service. So a narrow appeal, but also a very important right, because no one should be fired based on their partisan politics. So Congress, for many decades, has included this as kind of a narrow path to the MSPB. But it was only in regulation, which is kind of the difficult part, is that even though this was something that Congress has always found to be important in the merit system principles, the appeal right only existed via regulation. So what this probationary appeals NPRM does is, like Rashab said, it moves the appeal right to OPM and to a specific office of OPM, which handles some sort of adjudications, but it's a very small office that has not historically handled these types of claims. And maybe one important piece for all of these is that if you go to the MSPB, you have a right to discovery. You have a right to a hearing, and that's really where you get to to the nub of a lot of these cases. You could imagine if you're terminated, your employer has all of the authority over what actually happened. It can tell you as much or as little as the employer wants, and really you do need that discovery. You need those depositions, and you need the hearing to make your case. What this process does is it strips all that away. You have no right to discovery. You have no right to a hearing. It's all a paper process. So that's really makes it really difficult, as you could imagine, to actually build your case. Your employer can tell you as little or as much as they want. And if you're a probationary employee, they can just say, you're done here. And it's really hard to prove that it was because of something, even if you have a good sense that it was. So that's probationary appeals. Suitability is it's a determination by the agency that you are fit for your position. That has often traditionally been prior to your appointment. There's a process to determine whether your fitness and suitability for a position. And if you're not found to be suitable, there was a process to appeal that to the MSPB. What this does is, by a prior NPRM, it extends suitability to post-appointment conduct. So if you're sitting at a protest, for example, and your agency doesn't like that, things like that, it broadens the suitability categories, and it also extends it to post-employment conduct. And then, if you are found to be unsuitable, then you go not to the MSPB, where you have discovery and all these different rights. You go to OPM, where it's a paper process again. So it is all kind of, we talked about 1978 and the Civil Service Commission being split into these distinct parts, and that was all for a reason. OPM was the policy agency, and MSPB was the adjudicatory agency, and the FLRA handled labor issues, and OSC sprung from the MSPB, which was really the prosecutorial arm. And now you're seeing a lot of these put back into OPM in ways that Congress never intended.
And I think also that OPM is not set up to handle currently. I think that's another outstanding question, because that hasn't traditionally, since the Civil Service Commission was split up, hasn't traditionally been OPM's role. And so those sorts of structures and procedures aren't in place. So Rob, go ahead.
Yeah, Jenny, I would say that OPM should probably focus on processing people's retirement claims in a timely manner, as opposed to taking on new functions that they're not set up to handle.
Yeah, and that's there are a lot of folks, and I think that's a great flag, because we know a lot of people are still waiting, especially those who took early retirement and other things over the last year. So there's a lot that OPM still has on its plate too. Rob, while I have you off, are you seeing other questions? You've been great about grabbing questions as we've all been talking that we haven't gotten to yet, that we should still address before we get to the end here.
Right. There's some benefits related questions about folks that get put on Schedule PC, and the OPM guidance goes through some specific impacts. I think to things like student loan repayment and recruitment retention incentives. I don't think folks need to worry about their retirement or health benefits. You're still employees who are governed by those systems. So that's not affected. I think there's another person who's pointing out that there's some information in the final rule about SES being reassigned into schedule policy career, and I believe they'd have to be demoted first in order for that to happen, right?
Yeah, that's right. So they try to address that question that I kind of teed up earlier today about why a managerial tranche of employees would have adverse action rights and a sub tranche of policy employees would not. And what they say is that the president could always move the SES employee out of the SES and put them into something like scheduled policy career, for example, or it could remove the SES entirely from an agency. That's a drastic move that I'm not sure I've ever seen or heard of, but they say that because that's a possibility, that's what allows SES employees to retain these rights and to have a check on them, and that's how they justify that stratification.
Right, and then one more, Jenny, that I see here is about, like, might the administration move a bunch of people onto scheduled policy career and then just mass terminate them like they did with the probationary employees last year? And look, like I'm not gonna predict to what extent the administration might go to leverage its authorities. I would say that if they wanted to eliminate people in those jobs, there were other ways to do it. They could have held RIFs and things like that. And so I think what I'm trying to say, and I think what Rashab was adding on, is, like, don't assume just because you moved into scheduled policy career that automatically means that you're going to be terminated. We need to kind of see what happens next, and we don't know what's going to happen. But if that was their intent, I'm just pointing out that there's other ways they could already be doing that.
And I think, too, Rob, it's a good reminder, there's a lot of language in the Schedule PC final rule around poor performers and in some of the language OPM has used around this is a way to more easily deal with poor performers. Well, there's also a performance management system, and this doesn't make changes to agency performance management systems in terms of, goal setting and supervisors working with their employees and things like that. So again, there are other processes still that do apply to folks not in Schedule PC, and even on the performance management side that still apply to Schedule PC in terms of that. It doesn't make changes. So all of this means it's complicated and it's unclear at the same time, which is not an easy answer when I know people have a lot of questions.
Right. Yeah, it's hard. And I think perhaps one thing that people do when faced with that uncertainty is try to look ahead. And so there's a few questions about, hey, could this just be undone by a new administration with a new executive order? And I mean, the answer is essentially yes. Like, Schedule F was revoked and rescinded. OPM issued regulations that were very much consistent with the long history of strengthening civil service protections. Now this administration has issued its executive order and has issued its regulation. And so I don't think that's a good place for the federal workforce to be. And I would hope that we could get resolution once and for all that this Schedule F and now Schedule PC approach is inconsistent with the law. But the short answer is that a new administration could issue an executive order that rescinds the Schedule PC.
Yeah, there's a lot of moving pieces with all of this, and as we were just talking about all these other rules too. There's just a lot of parts and things going on right now, with potentially more to come. And so I do want to pause here for a moment and let my colleagues Georgia and Natalie, who have been so wonderfully producing this, put up a poll before we get, because I know we're getting towards the end of some of the questions and things, but if people have other topics or questions, because there's still a lot out there, please put those in this poll, because we are planning to set up more of these town halls, answer more questions. And so this is just a chance to do that as you all think of those on, those of you on the webinar here. But before we do end for the evening, I'd love to give each of you a chance to give me what's the thing you're thinking about still, either coming down the pipeline or something we haven't talked about tonight, or something, a smaller point that we just didn't bring up in this larger thing from Schedule PC that you want to raise. And so giving you kind of a broad chance to say something that hasn't been said, or to foot stomp something that has. And Rashab, you're off mute, so I'm going to call on you first.
Okay, thank you, Jenny. I think the first thing I wanted to mention, and while there's no guarantee in litigation, I did want to mention that there are several pending lawsuits challenging Schedule F. They will, likely be amended, based on the final rule. But that is out there. Democracy Forward is actually representing AFGE, AFSCME, and a few other groups in litigation. And then again, there's a couple of other lawsuits. And so again, while we can't predict what will happen, we believe in, and I'm sure all the other plaintiffs in these cases believe they have very strong arguments against this rule and Schedule F. And so that's out there. So just to put that out there. More broadly, I think again, I think one thing, and I understand there, someone on this in the Q&A mentioned they were from USAID, and so I know that there are many who have, experienced hardships and have not benefited from the activism of, the groups on this call. But I did want to mention that, there has been successful activism, right? Whether it's through litigation or, lobbying or other efforts, these coalitions have fought back, on these attempts to politicize the nonpartisan civil service, and people have been able to protect their jobs and continue to do what they care about. And so, I think there is hope out there, and it's because of, people are attending meetings like this and getting involved in their unions and working with groups like Democracy Forward that we're able to continue forward. And so I just wanted to put that out. And again, if there's anything AFGE can do for you, always feel free to, whether you're a member, whether you're in a unit or not, feel free to reach out to your local, the AFGE affiliate that represents your agency, and we will do our best to help.
Thank you for that, Rushab. And I know we've put AFGE's link in the website, and AFGE has not only information on legal and lawsuits out there, there's a lot of other info that each of our organizations is putting out there. And Jeff, there's that litigation tracker too, which if people are wondering about some of the cases, I think that Rashab mentioned, that's on the litigation tracker.
Yeah, I just want to note, and to follow up on what Rashab and some of the others saying, this is a rapidly changing environment. So Rise Up will do what it can to keep the resources current as to both the litigation tracker, our solidarity docket, and our dozen or so resource documents explain some of the laws as they change or as the situation changes. And if you have individual concerns, you can always come to Rise Up and get in line for a consultation at one of our clinics. We are trying to keep abreast of this rapidly changing environment and doing what we can to keep federal workers updated on what's going on.
That's great. Thank you, Jeff. Mike and then Rob, the thoughts on things we haven't touched on, anything else you've seen in the chat, other issues?
Yeah, I just want to, echo Rashab's point about the litigation. There are a couple of cases going on that are looking at schedule policy career, and they have been for many months, all dating back to the executive order. So right after that happened in January, litigation started, and nowadays is, developing based on this rulemaking. So there are, folks out there who are thinking hard about this and are pushing back in a lot of the ways that you all are flagging as potentially unlawful. But I would also just encourage you all to kind of keep abreast of OPM guidance on this. We are doing that, and we have resources that link to it. But every few days, they tend to post a new bit of information that is at least helpful to the public to better understand what they're doing. There are at least 2 guidance documents they've already put out, which we've linked in one of our resources on schedule policy career. There's an FAQ that answers some questions there. To what extent, we agree with that or not, I think that it is the position of OPM on how they're going to interpret this, so it's worth reading. and just kind of try to keep up with what your agency is telling you about these positions. I know a lot of this is moving very quickly and it's very daunting and overwhelming, but it is the time to kind of dial in and see, try to get as much information as you can from your agency, from any HR folks, from your union if you're in a union, and keep tracking groups like ours, which will keep putting out information that we think is helpful.
That's right. And Rob, go ahead and jump in there.
Yeah, sure. So just to follow up on Rashab and Mike, so Democracy Forward has filed over 400 lawsuits against this administration, and we have obtained over 100 favorable orders from judges appointed by presidents from both political parties, including judges appointed by Donald Trump himself. Sometimes the case goes our way, and then there's an appeal, and many of those cases are still being actively fought. Sometimes the administration gives up. They do. Sometimes in the face of litigation, they change their position. And we did see some of that, for example, with probationary employees being brought onto the job. We saw the threat of rifts during the government shutdown that were abandoned. So the fight is important, and we got to keep it up. But as I mentioned before too, this is a terrible way to run a government. Like, we can't be whipsawing employees with Schedule F, Civil Service Protection, Schedule PC, dueling executive orders. It's just not good. So we really do need to come together and think about a better way forward. And I think that folks who have been on the front lines of this have a lot to say about changes that would help make the government work better for everybody. And so I would encourage you to check out our Democracy Works 250 project. You can go to our website, democracyworks250.org. And that is a place where you can find information about what we're doing to reimagine government. We work with a lot of great partners, including Jenny and the Partnership for Public Service, who have their own project as well that's looking forward. And so know that there are people that are thinking every day about how we emerge from this, come out in a better place, and that we want to engage all of you in that discussion.
Yeah, Rob, that's such a great point. Is this, while we're all trying to help support current and former feds, we're also trying to figure out how to make the government work better. And they are two separate things, but also related, because having a system and a structure that works for the federal employees in it is incredibly important to all the things that government does. I do want to say a couple things. Is that, again, this is going to be going to be posted on YouTube and on FedSupport.org. We'll send it out through our partners on here. So if there are questions that you want to circle back to, questions that weren't answered, you can always email us too, and we'll try to get you to resources to any of our partners and colleagues on the line here. Or also, if there are topics that, again, you didn't have a chance to put in the poll or that you want to know more about, let us know, because we're trying to figure out what resources best support those who recently left federal government, and also those who are still in federal government, because I know a lot of my friends who are still inside federal government are holding down multiple jobs. They're dealing with a lot of questions and uncertainty. There's budget uncertainty. And so it's a really tricky, tough environment to be working in. And so let all of us know what we can do to not just answer questions, what resources are needed, what support we can give you, because it is really important, the work that you all are doing. And so just know that we are all here to try to help provide some of those resources out there as best we can. So with that, I know we're getting close on time here. So want to thank all of our folks on the line here for all of the great information. And again, we'll come back with more information as we see these rules play out, as more come out there. We expect more of these rules to be coming. So we will have more resources and more webinars to come. We do have our FedSupport.org hub, where we link to all of the groups on the line here: AFGE, Civil Service Strong, Rise Up. Each of us has our own set of resources available to folks. So please reach out and look for those. And again, let us know what else you need. And In the meantime, really want to thank you all for being here this evening. To our speakers, thank you to all the folks who joined us on the webinar. Really appreciate your questions and just everything that you all are doing and coming together with us. So with that, I will say final thanks, and you will see us again talking about these issues. And in the meantime, I hope everybody has a great evening.